Welcome. Today we will be discussing about intellectual property rights and ethical issues related to it. Let us see the outline of today's discussion. So, in this module we are going to discuss about what is intellectual property right. We will discuss about the different categories of IPR. What is the intellectual property chain of activities? We will discuss in why intellectual property is an intangible property, why intellectual property needs protection, how IPR is managed today. We will discuss about patent, its meaning, protection, rights of patent owners and what can be patented. We will discuss about trademark, meaning, purpose, what can be protected as a trademark. We will discuss about industrial design, meaning, why protect industrial designs and what can be protected as an industrial design. We will discuss also about geographical indications, meaning, why geographical indications need protection, geographical indications versus trademark. We will discuss about copyrights and related rights, meaning what protect copyrights, rights of holders, advances in technology and copyrights, benefits of copyrights and other related rights. And we will also discuss about World Intellectual Property Organization. So, first we are going to discuss about what is intellectual property. So, intellectual property is a category of property which is the intangible creation of human intelligence, and it mainly covers copyrights, patents and trademarks along with other types of rights such as trade secrets, publicity rights, moral rights and rights against unfair competition. There are different categories of intellectual property right and we are going to see them over here, like what are the different categories. It can be divided into two main categories. One is the industrial property, which includes mainly patents for inventions, trademarks, geographical indications and industrial designs, and copyright, which covers the literary works like novels, poems and plays, films, music, artistic works like drawings, paintings, photographs and sculptures and architectural designs. We will discuss now about the chain of activities which are involved in intellectual property. So, the chain of activity includes creation, innovation, commercialization, protection and enforcement. Creation is the coming up of a new product. Each of the stages are important for intellectual property and rights and its protection. So, when we tell creation, it is coming up with a new product. Innovation, it is something which is not seen before. Commercialization, which is execution and availability for selling, so you can make money or profit out of it. Protection is registered under law, and enforcement, which is cannot be copied or stolen as per law. So, why we are so concerned about intellectual property and why it is so important to protect it? Because it is an intangible property. Now we will discuss why intellectual property is an intangible property. So, tangible property is a property which can be touched physically, like land, houses, bikes, cars, etc. Intangible property is something which cannot be seen or touched, which can be easily appropriated, and cost of reproduction is negligible. Because of these two things, like it can be easily appropriated and cost of reproduction is negligible, it is very important to protect this intangible property, which is the intellectual property is an intangible property. So, why this intangible property needs protection? Because there is always an high expenditure in creation of a new product or design. It involves high research activities to avoid free riding problems like usage of own property by others for free, maintaining loyal followers, and inhibiting like Me Too type of creations in grey markets, and to retain the profits. In this we see the different types of intellectual properties: patents, trademarks, industrial designs, geographical indicators, and copyrights. We will discuss the meaning of each and the details of each in the subsequent slides. We will start with patent. So, a patent is an exclusive right granted for an invention, a product, or a process that provides a new way of doing something, or that offers a new technical solution to a problem. So, this is what the word new is important over here. It provides, it's granted for an invention, a product or process that provides a new way of doing something, or that it offers a new technical solution to a problem. The patent provides the patent owners with the protection for their inventions. Protection is granted for a limited period, generally for 20 years. Now, it may question may arise in our mind, like, are patents necessary? Yes, of course it is necessary, because they offer incentives and rewards to individuals by recognizing their creativity, and to come up with new marketable inventions for the benefit of the common people. The protections that are offered by patents are: the patent protection, it implies that the invention under patents cannot be commercially or otherwise used by other persons for generating profits or any other commercial returns. It cannot be recreated, sold, or shared without the owner's consent. Patents are usually enforced in courts, and courts can also cancel patents in the case the claims of the third party are found to be right, if at any altered stage. So, if it is found, like I have applied for a patent, but it is not an original idea that I have done, and maybe I have taken portions from others' ideas or inventions, and then we have incorporated it in our design, and we are claiming like it is a patent. Later on it may get rejected. the patent gives certain rights to the patent owners. So, they have the rights to decide who can or who cannot use the patented invention. Owners have the right to give permission to offer license to other parties on mutually agreed terms. Owners can also sell their rights to other persons if they wish to do so, and then they become the new owner of the patent. Once the patent expires and the protection ends, then it has to enter into a public domain. This is also called off patent, in which the current owner of the patent no longer ceases to be the owner, and this patents in public domain may act as inspiration for others to move with this invention forward, add new dimensions to it, and take up a research regarding it and improve on that. Now, what is the role of patents in our everyday life? So, what we see, like every aspect of our day-to-day life has been surrounded by designs or products which are like patented, like the shape and design of the coffee mug or the fans on the ceiling above our head could be patented. Like it is well known in the case of electric lighting, patent held by Edison and Swan, and the sewing machine, patents were held by Hoy and Singer, and iPhone, patents held by Apple. These are things we see very normally in our surroundings. Now, it is very important, like all the patent owners are required to share their information in public domain. These can be used by other people for carrying out, derive inspiration for carrying out further creativity and innovation. Now, one of the very important question is, can all the inventions be patented, or there needs to be certain criteria which the invention has to meet before it can be patented and patent protected. So, first is it must be of practical use. Second, it must carry some novelty. Third, new characteristics must exist which is not a part of an existing knowledge. In many countries, scientific theories, mathematical methods, plants, animals, varieties, discoveries of natural substances, commercial methods, and methods of medical treatment are not generally patentable. Why? Because if we understand from this discussion, like if this is patented, then it stops like the further use of it to improve on it, to criticize it, and maybe add new qualities to it maybe for the next 20 years, and the progression is stopped. So, these type of things which requires like newer versions to come up as quickly as possible, so that which is better for the like greater good of the greater public in society at large. So, that is why these are not generally patentable. Next, we will discuss about trademark. A trademark is the distinctive design which identifies certain goods or services produced or provided by an individual company. So, trademark is the distinctive design which identifies certain goods or services produced or provided by an individual company. It is like a stamp that you get. Its origin can be traced back to ancient times when weavers or craftsmen would mark their signatures or remarks on their artistic work, which gives it a sort of stamp like this has been produced by me. These marks in the present scenario are called trademarks. It helps consumers to identify and purchase a product or service based on whether its explicit characteristics and quality as indicated by a unique trademark meet their needs. So, as it is claimed by the trademark about the qualities and it may be the nature of the product and all, so it is a assurance of that. The trademark is the assurance of that quality and the nature of the goods and services. So, it gives the customer helps the customer to identify and purchase a product based on that trademark. Now, what are the purpose of a trademark? Trademarks ensure that the people who own these trademarks have the right to use these to help others identify the goods and services and also to allow others to use this in return of a predetermined payment. In a broader sense, trademarks promote enterprises globally by rewarding their owners with recognition and financial profit. So, if we always go by a trademark, then obviously we are giving recognition to the owners and it brings a financial profit to them. So, trademarks also protect the unique property of someone of being like used or copied by others for producing counterfeit products. So, like fake products. So, if we have a trademark, then it puts a restriction on others to create similar kind of things and like sell it by developing this lookalikes which may be poor in quality as compared to the original company who is having the trademark. Now, we have to understand what all can be registered as a trademark. So, trademark can be a combination of words, letters and numerals. They may consist of drawings, symbols or three-dimensional signs such as the shape and sign of a packaging of goods. It can be holograms, it can be motions, colors and non-visible signs like sound, smell or taste. So, these can be different things like ISO certifications which can be used as registered as trademarks. So, what are the other some categories of trademarks are? Collective marks. It is owned by an association whose members use them collectively. Such associations might represent professionals like accountants, engineers or architects. So, this is like everyone has their own symbol which speaks of certain things and certain values, certain like vision, mission, and it is represented by that picture or a trademark, and it defines clearly in the mind of the customers what to expect from these organizations based on the trademark what is given. Next important question is, how can we apply for a trademark? Application for registration of a trademark needs to be filled with the appropriate national or regional trademark office. The application must contain a clear reproduction of the sign field for registration, including any colors, forms or three-dimensional features. Finally, the right applied for cannot be the same as similar to rights for already granted to another trademark owner. So, before granting a trademark, lot of cross checks is done, lot of checks are seen to see like whether these are not already overlapping with the trademark that is given to another owner. Next, we will talk about industrial design. So, industrial design talks of the ornamental or aesthetics aspect of an article. The design may consist of the shape of the article, pattern, size, color or two-dimensional features. Industrial designs are applied to a wide variety of products and handicrafts. These products may include medical equipments, watches, luxury items, jewelry, electrical items, housewares, textile design, luxury goods, etc. So, industrial design focuses mainly on the ornamental or aesthetic aspect of an article. To be protected, like what can be protected as industrial design is it should be new, like should be different from design which is already protected, and should be non-functional. So, under industrial design we cannot protect for technical features, they can only be covered under patents. So, why we are discussing this finer things is, sometimes we are not able, given a condition, sometimes we are not sure to understand whether to file for a patent or trademark or like industrial design or copyright. It may so happen these are very overlapping concepts with one another and we get confused about it, but there are certain fine threads, fine lines which define, like if this is the case then you go for this. One such thing is this non-functional aspect of the industrial design which is mentioned, like technical features cannot be protected under designs, they can be only covered under patents. Then why it is necessary to protect industrial designs? Designs make a product appealing and increases its marketability, so it must be protected. When an industrial design is protected, the owner, which could be an individual or a firm, are assured an exclusive right against unauthorized imitation of the design by others. This helps the owners to assure a fair return on investment. It also promotes fair competition and honest trade practices. It helps to promote creativity as people feel assured that their designs will not be stolen. So, if we are in the fear of things getting stolen, then it may not, like we may not be able to express our ideas in its fullest form. But when given for this protection of this creativity and this aesthetic aspects and maybe the minor things which increases the worth of these things, then it helps to promote creativity further. Next, which all industrial designs can be protected? So, those designs which carry an element of newness. New here means they should not be similar to designs which have already been protected. Normally, the term protection granted is generally for 5 years with the possibility of further renewal, in most cases up to 15 years. Next, we will discuss about geographical indications. Geographical indications is about the signs which are used on goods to design, which is the belongingness of the good to a particular idea, particular region or particular location. We will discuss the details of it. We will try to discuss how it is different from trademarks. We will discuss about copyrights and the details of the World Intellectual Property Organization in the next class. Thank you.